Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is a special YouTube live stream being broadcast live Wednesday, June 27th, 2018 at 9 p.m. Eastern Time. And this live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, please feel free to ask questions in the YouTube live chat at any time, and I'll try to keep an eye on that and answer questions as they come up. Now, in this episode, I plan to cover the court's final week of opinions, in which the court handed down opinions in 6 cases, including several pretty high-profile cases. Now, if you're listening to this, you're probably aware that earlier today, Justice Kennedy announced his retirement effective July 31st. This is big news for the court, and the confirmation battle that's about to get started is undoubtedly going to get very ugly. It's going to be very contentious and hard-fought. There's a lot to say about this. There's a lot to say about Justice Kennedy's career on the court, about his potential successors and the court's future, and about the confirmation process itself. But unfortunately, that's not for tonight. I've just got too much material to cover already. And frankly, I just haven't had enough time to really process it and get my thoughts collected. So for Counting to Five, Kennedy's retirement will have to wait. But if you are watching live and have specific questions, feel free to ask them in the live chat, and maybe I'll have some thoughts to share. But as I mentioned, there's a lot to cover here. So this episode is going to be focused solely on the opinions, not on other recent orders and other developments at the court. Now, tomorrow, that's Thursday, June 28th, I'm going to be doing another live stream. That's at the normal weekly time, Thursday at 9 p.m. Eastern Time. And my plan was to do kind of a term wrap up and a look ahead to next year. I'm still debating whether I should try to tackle Kennedy's retirement tomorrow. But in any event, please join me again tomorrow for this kind of term wrap up and look ahead live stream. But now let's get on to the opinions. So I mentioned that in this last week of the court's term, the court handed down 6 opinions. There was 2 on Monday, 2 on Tuesday, 2 on Wednesday. Just briefly, here's what there were. On Monday, there was Ohio v. American Express, and that's an antitrust action related to American Express's so-called anti-steering rules. We'll talk about that more in a bit. And then there was also Abbott v. Perez, which was a case out of Texas about racial gerrymandering. On Tuesday, there was NIFLA v. Becerra. That's a case out of California about a California law requiring crisis pregnancy centers to give certain disclosures. And also on that day was Trump v. Hawaii. That's the travel ban litigation, the Trump administration's policy barring entry into the country from nationals from certain foreign countries. And then finally today, this morning, Wednesday, June 27th, the court issued 2 cases. One is Georgia v. Florida. Now, this was a interstate water dispute. This is kind of a highly technical case about apportioning certain water between Georgia and Florida. But the other case, on this last day of the term, was Janus v. AFSCME. And this is the case about the constitutionality of union agency fees. Those are fees that unions charge to non-members to cover the costs of collective bargaining and other union representational duties. And so I'm going to try and cover all 6 of those cases. I'll try and move pretty quickly through them. But again, if you have any questions and you're watching live, please feel free to ask them in the live chat. Now, the theme for this week, as you'll see as we go along, is 5-4 decisions. All 6 of the court's decisions this week were divided 5-4. Now, it's not unusual for more of the closely divided cases to come down toward the end of the term. The divided cases tend to take the court longer. There's more back and forth between the majority and dissent, and sometimes multiple different opinions. So there's usually more unanimity earlier in the term and more sharp divisions late in the term. But it is unusual to end with just this string of 5-4 decisions. And what's more, of these 5-4 decisions, 5 of them, fully 5 out of these 6 decisions, split directly along the stereotypical ideological lines, with the 5 more conservative justices in the majority and the 4 more liberal justices in the dissent. Now, there's often close court watchers often warn people not to overstate the ideological divides on the court. There is a lot of unanimity. There's a lot of crossover voting. There's a lot of unusual alignments of justices in various cases, but there is a real division on the court, and this kind of just really highlights that, having 5 out of the 6 cases that came down this week split along those same lines. And it's something significant, especially in light of Justice Kennedy's announced retirement, something that a lot of people have been noting. This term, there's in the number of 5-4 decisions that were issued by the court this term, there wasn't a single case that involved Justice Kennedy. Where the 5 justices in the majority were made up of Justice Kennedy plus the 4 liberal justices. Now, Justice Kennedy is considered the swing vote on the court. He's kind of the median justice if you're going to arrange the justices in kind of a linear fashion, from liberal at one end to most liberal at one end to most conservative on the other. Kennedy is the one who falls in the middle of those 9 justices, and in some significant areas of the law, he has sided with the more liberal justices to give them a victory in certain areas. Notable ones are in certain abortion cases and in a recent affirmative action case. But this term, there was none of that. In every single case that split along those ideological lines, Kennedy sided with the other 4 more conservative justices, and that's unusual. In a typical year, it's closer to 2 to 1 in terms of siding with the conservative justices and siding with the liberal justices in those closely divided cases. But here 100% of the time in this term. So it's just an interesting trend to notice this year. But now let's just dive in and get started with the cases. So again, 2 cases on Monday. The first one I'm going to discuss is called Ohio v. American Express. And again, I mentioned this is an antitrust case. Now, this case was one of those cases that divided 5-4 along those conservative liberal lines, with Justice Thomas writing the majority, joined by the other conservative justices, and Justice Breyer writing the dissent for the 4 liberal justices. Now, the background of this case is it was an antitrust action that was brought by the United States and a number of individual states against American Express. And the target of this is something known as the anti-steering rules. And these are rules that American Express imposes on the merchants with whom it has contracts, the merchants that accept American Express cards. And the anti-steering rules prevent those merchants from taking any action to steer customers away from using American Express. So that would include them just verbally encouraging customers to use a card other than American Express, but also includes practices like giving discounts or certain incentives to customers who use a card other than American Express. And this antitrust action was brought arguing that that's anti-competitive behavior in violation of the Sherman Act. That's the major antitrust act. And the specific issue here is about how to analyze antitrust actions in what's referred to as a two-sided market. So the argument here is that antitrust is American Express is participating in something known as a two-sided market. They're what's referred to sometimes as a two-sided platform. And what that means is that American Express stands in the middle of 2 separate markets. American Express has its relationships with merchants, so it has merchant relationships, and it serves as a it provides the payment services to those merchants who accept American Express cards. And then on the other side, American Express has its relationship with the card holders, and it acts as an intermediary between these 2 sets. And the issue here is in the antitrust cases, this is under Section 1 of the Sherman Act, and it deals with certain types of anti-competitive behavior. Here's the language of Section 1. It refers to, it says, quote, "Every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal." Now, this is extremely broad language referring to every contract or combination in restraint of trade, and it's been interpreted over the more than a century as referring only to unreasonable restraints of trade. And the court has developed rules that kind of classify these into two different types. There's some types of restraints on trade are evaluated as they're considered to be per se violations of antitrust law. They're automatically illegal if they're done, and this typically involves what are referred to as horizontal restraints. This means agreements between direct competitors in the marketplace. So, for example, agreements to fix prices or agreements to carve up the market so that two competitors aren't competing head to head. Many other types of restraints on trade are evaluated under something known as the rule of reason. And this is kind of a balancing test where the court looks at pro-competitive and anti-competitive effects and balances these. And that's usually used when we're dealing with what's known as vertical restraints. So that's when, for example, two different there's an agreement between companies at different points in the supply chain, for example. So between a manufacturer and a retailer, or something like that. And these rule of reason cases are evaluated under what's called a burden shifting framework. And the way this works is the plaintiff, so whoever's alleging the antitrust violation, here that would be the governments that are involved here, the state and federal governments that are involved here. They have the burden to first demonstrate that the restraint on trade has anti-competitive effects. Once they've made that showing, then the burden shifts to the defendant to show that in fact the arrangement has pro-competitive benefits. And then if they are able to do that, the burden shifts back to the plaintiff again to show that that pro-competitive benefit could have been achieved with less restraint on trade. So that's the basic framework of these rule of reason cases. Now, here's the issue here. The argument is the district court in this case found that these anti-steering rules had a anti-competitive effect in the market for the merchants, the merchants market for card to deal with the credit card companies. The American Express argued that this is the wrong way of looking at this because it's this kind of two-sided market. You can't show anti-competitive effects unless you look at both sides of that market. You have to look at the impact on a particular rule on both the merchant side and the customer side. At the Court of Appeals, it was the Second Circuit Court of Appeals, the Court of Appeals agreed with American Express and found that the plaintiffs had not met their burden of showing an anti-competitive effect because the effect was not there when you looked at both sides of this market. So that's the way this came up to the Supreme Court, this question of how do you evaluate these two-sided markets when you're doing this rule of reason analysis. So Justice Thomas wrote the majority opinion, and he starts just by discussing the basic facts that he argues are relevant about these two-sided markets. And one is that these two-sided markets have are characterized by what are referred to as indirect network effects. And this is the idea that increasing one side of a two-sided market. So in this case, having a larger number of merchants who accept American Express cards is a benefit to the other side, the people on the other side of the market. So the cardholders benefit when there are more vendors who accept American Express, and the other way around also applies. If there are more cardholders for a particular card, then that's more benefit flows to the merchants. So a merchant gets more benefit out of accepting a card if there are more cardholders. And just very briefly, there's a question here from Sam in the live chat, and it says, "I'm assuming the rule of reason test is not in the Sherman Act, so was it formulated by the Supreme Court itself?" Yes, it was, and the Sherman Act is often cited as it's kind of the prime example of what's sometimes characterized as a common law statute. And the idea is the Sherman Law is stated in such kind of broad general terms that it doesn't really explain exactly what courts are supposed to do or exactly what is or is not a violation. It's just phrased in these very general terms about restraints on trade. And as a result, all of antitrust doctrine has basically developed out of that just very, a single sentence in the Antitrust Act gets developed out of the case law over, now more than well over a century, into various tests to apply to various different types. So all these concepts of vertical restraints versus horizontal restraints and per se violations versus the rule of reason, all of that stuff is developed in cases over the years, and none of it comes directly out of the statute. Now, this is contrasted with a lot of more modern statutes that have highly detailed regulatory regimes. They may spell out, specific burdens of proof or evidentiary standards that have to be met, and may, give detailed specifications of things that are and are not allowed. Well, the Sherman Act is the polar opposite of that type of statute. So yes, so this has all been developed over the years. And one thing that people who are proponents of the way antitrust law has developed, one thing they've pointed to is they've said that this kind of flexibility in the antitrust law has allowed the court to develop antitrust law, taking into account new developments in economic thought over the years. So antitrust law now is considered to be like far more economically sophisticated than it was maybe 50 years ago, because there's just been so much scholarship on competition and all the factors that are important for antitrust, and these have kind of made their way into legal discourse and into court rulings. So that's an argument on for that kind of approach on that side. There's arguments against it, obviously. And Sam follows up. So we should think of antitrust cases like tort cases? Well, in a sense, yeah, because traditionally tort law, and this is still the case to a large degree, tort law is developed by the courts. It's mostly judge-made law. It's common law. Now that this isn't always true. Sometimes legislatures step in and will set certain rules and overrule certain decisions of the court. But in the main, it's developed over time by judges in court decisions. And antitrust law, even though it derives its authority from this statute that dates back to 1890, it's the actual doctrine and the development has been largely done in a common law method, a case-by-case development by judges. So yeah. So back to the case. There's these indirect network effects in two-sided markets. So benefits increasing the participants in one side of the market, benefits participants in the other side of the market. And the platform, so the platform in this case, that would be American Express, they're the intermediary between these two sides. The platform has to take into account both sides of this market when it's doing things like pricing its services. And often in these two-sided markets, it will treat the two sides of the market differently because there's different price elasticity in the two sides. The one side or the other may be more sensitive to price changes. And in some cases, one side of that two-sided market may even be subsidized to a heavy degree because the platform is able to get a lot of earn its revenue out of one side of the transaction, provide that subsidization to the other side of the market, and then the benefits flow back to the first side by the increased participation in the one side. So that's the basic argument here, is that both sides of this market have to be taken into account because of this unique these unique effects that flow across the two-sided market. And the argument here is that that's what happens here, according to American Express. The money they make from the merchant side, and that's the bulk of their revenue comes from the merchant side. That allows them to subsidize the cardholder side by providing various benefits and rewards to cardholders. But that according to American Express, the merchants ultimately benefit because those benefits that are provided to the cardholders increase the number of people who want to hold and own and use American Express cards, which flows back to the benefit to merchants who accept American Express by having this larger cardholder base. That's the basic idea here. And so the argument by Justice Thomas is that when you're defining an anti-competitive effect, so that's the step one of this rule of reason burden shifting, it's essential to first define the relevant market. and the relevant market is the area of effective competition. Now, in certain markets, this just means figuring out who are the direct competitors. So if you have a particular product, what are the substitutes for that product? What are the other things that are being traded off against it? But in this case, with a two-sided market, Thomas's argument here is that the relevant market, the market that's actually being participated in by American Express, is this two-sided market, and that whole two-sided market needs to be taken into account. And he makes several kind of economic arguments about evaluating things, the prices and things that happen in these two-sided markets. And one argument is basically the product here shouldn't be viewed as one side of this in isolation. So the product isn't just the payment services provided to a merchant by American Express. The product is the entire transaction from going from a cardholder through American Express to a merchant. That entire transaction is a jointly consumed product by the merchant and cardholder. So it's necessary to look at the total costs of that entire transaction, not just the costs on one side of that transaction, due to the two-sided nature of these markets. And he says that in this case, the plaintiff's entire anti-competitive case is based on the increased merchant fees that are enabled by the anti-steering rules. But Thomas says that what the plaintiffs have failed to show is evidence that there would be a higher overall price for transactions in total, or that the overall price for transactions is higher than it would have been absent these anti-steering rules. And he responds to a counter argument that these higher merchant fees are not completely offset by higher spending on benefits on cardholders. So that would suggest that the total cost of these transactions has risen. But he points out that the total volume of transactions has also increased, and argues that under the economic theory says that when there's a rising price, but there's also rising output, so more total transactions happening, that's consistent with a demand-driven explanation, that just demand is increasing, and the rising price and output are a result of that demand, and not evidence of market power being used by American Express. And he also argues that there's no evidence here that competition in this space has been stifled. He says that there's evidence that there's expanded output and improved quality in the marketplace, increased availability of credit cards, and the competition has in fact periodically forced American Express to lower its merchant fees. And also that Visa and MasterCard have competed for merchants on the basis of lower fees. So he says there's a very competitive market here. And then further goes on to talk about the anti-steering rules particularly, and says that there's nothing inherently anti-competitive about those anti-steering rules, because they address a negative externality caused by merchants steering customers away. And the general idea is that if a cardholder finds themselves being steered away from using a particular card by a merchant is trying to discourage them from using a particular card, then that causes these spillover effects where the cardholder will be wary of using the card elsewhere, because they don't want that that unwelcome or that uncomfortable experience of being steered away from it by the merchant. And that's an externality caused by merchant steering. And so this is a legitimate means of trying to combat that externality. And so the conclusion by Thomas is that the plaintiffs failed to meet their burden under the step 1 of the burden shifting framework. And so there's no, under the rule of reason, they haven't showed an antitrust violation. So the dissent is by Justice Breyer. He agrees that the rule of reason 3-step burden shifting framework is the right approach here, but he disagrees very strongly with the majority's analysis, the way they went about it, and he points out that the practice of steering, the practice of merchants giving incentives or benefits to use one card over another, that practice allows price competition to occur at the merchant level. It allows, because normally customers are completely oblivious to the merchant fees. They're entirely hidden, and a customer doesn't have any incentive to take that into account when choosing to use one card over another. And so the practice of steering allows price competition at the register. And so that's good for competition in general. And Breyer points to some of the district court's factual findings, the fact that American Express repeatedly raised merchant fees and apparently had no concern about losing customers due to anti-steering rules, because anti-steering rules would kind of prevent customers from choosing other cards due to merchant fee increases, because they wouldn't feel that increase. And in fact, American Express didn't really lose any major merchants or significantly increase its cardholder benefits when it raised merchant fees, and that kind of demonstrates American Express's market power. He also pointed to the experience of Discover, another competitor in the credit card space. And Discover had attempted to market itself on the basis of low fees by encouraging merchants to engage in steering toward its low-fee cards. But this was effectively blocked by American Express's anti-steering rules. And the district court found that there were no offsetting benefits to consumers of this anti-steering practice. So the conclusion in the district court was that there was no incentive now to compete on low fees. Consumers see higher prices. They don't receive any of the benefits they would have received potentially from being steered. So any incentives merchants would have offered them to go to a lower cost card. And so Breyer says that should be enough to meet the burden under step one. That's enough. But he goes on to discuss a little more about the majority's two-sided market discussion, and he makes a couple arguments. One, he says, is that this concept is too broad, that there's so many different markets that can be characterized as two-sided markets, and that this is just a much too broad of a classification. He says that he points out that this is just not a category that the Supreme Court has dealt with before. Two-sided markets are not something that appears in any of the Supreme Court's antitrust cases. And he doesn't see why it should be treated any differently than any business that's involved in multiple different markets. The two services there are not substitutes, so cardholder benefits or the service provided to cardholders and the service provided to merchants are not substitutes for each other, so they're not competing in the market, so there's no reason that you need to lump them together in a single market. And he also argues that the majority's version of a two-sided market differs from the way economists typically discuss two-sided markets. The majority's definition is according to Breyer, quite a bit broader than the way economists usually deal with it. And economists say that the relevance of a two-sided market it differs from case to case. It's a very case dependent, how the two-sided market will affect market power and competition. And so he says that the fact that something is a two-sided market just doesn't provide any justification for always having to lump both sides of the market together for antitrust purposes. But then he argues further that the burden here was met even under the majority's market definition. He says that the increased merchant fees without a corresponding increase in cardholder benefits that is enough to show that there was an anti-competitive effect. He says the majority's argument that this was equally plausibly caused by increased demand in the market. So demand is an explanation for both the increased costs. Breyer argues, says that if this is the justification, then it makes it effectively impossible in a situation where demand is increasing to prove an antitrust violation. And so he believes that he says American Express he thinks that the burden has been met to show that there's an anti-competitive effect. He thinks American Express should still be able to argue that there's a pro-competitive benefit under step 2 of the balancing test, though he thinks that's a pretty high burden because he thinks that it's usually you can't be allowed to trade off a harm in one market for a benefit in the other. So the fact that consumers, cardholders may be benefited by these arrangements doesn't make up for the fact that merchants are harmed by those same policies. And he argues that the majority basically ignored the district court's factual findings against American Express on the pro-competitive benefits. So that's it for Ohio, the American Express. So move on to the next case. This is Abbott v. Perez, and this is a case out of Texas about racial gerrymandering, or more broadly, challenges to the use of race in districting. And this again was another 5-4 conservative liberal split. So with Justice Alito writing the majority for the 5 conservatives, Justice Thomas concurring, joined by Justice Gorsuch, and then Justice Sotomayor with the dissent, joined by the other liberal justices. Now, this was 2 consolidated cases that were challenging Texas electoral maps. One was about federal congressional districts, and the other was about state house districts. But the issues are very largely, they're overlapping, largely the same. And the basic history in this case is this. In 2011, Texas enacted new electoral maps following the 2010 census. Now, these maps were almost immediately challenged in court, and there was various allegations of racial gerrymandering, impermissible use of race in districting. Now, in 2012, the litigation was ongoing, but the district court ended up drawing an interim map for use in the 2012 election. That interim map was based on the 2011 map. It carried some districts over directly from that map, but it made other changes to cure various problems with the map that had been identified in the litigation. So that 2012 interim map was used for the 2012 election. Now, in 2013, the Texas legislature adopted that 2012 interim court plan as the new map going forward. And that's the map that's been used in Texas since 2013. Now, the litigation that started back in 2011 continued. And finally, in 2017, the district court held that the 2013 plan was impermissibly race-based. It was the impermissible use of race in districting, and the decision was in part because the 2013 plan was tainted by the impermissible racial motives involved in the 2011 plan, and there were challenges to a number of districts on the basis of those impermissible racial motives that were involved in the 2011 plan, and the argument was that those motives carried through into the 2012 district interim plan adopted by the court, which was later adopted by the state. But there were also some specific challenges made to certain districts under the Voting Rights Act. Now, this case also had a jurisdictional issue. This was heard by a three-judge district court panel. That's how these redistricting cases are heard. Instead of a single judge at the district court level, they're heard by a 3-judge panel. Now, the Supreme Court can hear appeals from these 3-judge panels, direct appeals, when those panels grant or deny an injunction. But here what happened is that district court declared the maps invalid, but didn't explicitly enter an injunction. So didn't issue an order saying that the state could not use the existing map going forward. It just said that they were invalid and said that they needed to be remedied. Now, Texas appealed to the Supreme Court, arguing that this is functionally an injunction, that by saying that these maps were invalid and a remedy needed to be made, it is functionally acted as an injunction, and that should be good enough. Because it effectively prevented Texas from using the maps and requires it to draw up new maps before the next election. So that's the jurisdictional issue, but then there's also the issue, the issue on the actual redistricting, on the merits of it. There's an argument about the discriminatory intent present in the 2011 districting and whether that carries through to the 2013 map. The argument on the other side was that the legislatures were especially relying on district court's rulings in 2012 when the interim map was created, that map had been made to comply with certain legal requirements. So it was reasonable for the 2013 legislature to adopt that map to avoid future litigation and take something that had already kind of been blessed by the court. So that's kind of the arguments on the two sides. And now Justice Alito writes the opinion for the majority, and he finds sides with Texas for the most part, except for one district, which I'll come back to at the end. But he basically says that the district court kind of reversed the burden of proof. He said that the burden is on the challengers to the map to show that the 2013 legislature acted with discriminatory intent. it's not the state's burden to show that they have somehow cured whatever taint existed from the 2011 legislature's actions. Now, on the jurisdictional question first, whether this could, whether the Supreme Court could hear this at all due to the lack of a formal injunction, Justice Alito argued that under court's precedents, orders that are effectively injunctions, those can be treated as injunctions for purposes of these appeals. And he talks about there's two separate provisions that are at issue here. One is a provision that's known as 1292A1, and that's a provision that applies in most district court actions that allows an appeal of an injunction, the grant or denial of an injunction, to the Court of Appeals. In most cases. But there's a separate provision, this is section 1253, and this is a provision that allows the appeal of these 3-judge district court rulings, an injunction, grant or denial of an injunction in those cases directly to the Supreme Court. Now, the first provision I referred to that allows most cases to be appealed to the Court of Appeals, that has an exception. It doesn't apply when there's this direct appeal available to the Supreme Court. Now, there are cases under 1292A1, that's the one about the normal appeals up to the Court of Appeals, that say when an order has the practical effect of denying an injunction, it can be appealed. And Justice Alito basically says the same thing should apply to 1253. They're very similar statutes, they have very similar language, so the same thing should apply. And he also points out what he regards as a strange anomaly if you didn't treat it the same. If you said that this kind of practical injunction, something practically equivalent to an injunction, if that wasn't enough to meet the requirements of 1253 to get this direct appeal up to the Supreme Court, but it was enough to meet 1292A1, well, the exception for things that are appealable directly to the Supreme Court wouldn't apply because you've just said 1253 didn't apply. So this would be appealable up to the Court of Appeals. So you'd have a strange situation where Congress has said that these 3-judge cases, when there's an injunction or grant or denial of an injunction, these 3-judge district courts should go straight to the Supreme Court. But in this subset of cases where it's these practically equivalent to an injunction cases, you'd have that instead going to the Court of Appeals anyway, because it didn't. You say it's not enough of an injunction to go to the Supreme Court, but it's still enough of an injunction to appeal under this other provision. And he says that would just be anomalous. There's no way Congress could have meant that to happen. And so he says that these orders, they meet this practical test. They found a violation. They declared that it must be remedied, ordered the state to attend remedial hearings in order to consider how to remedy the situation. So he said basically it was understood by the people involved that this kind of effectively barred the use of the existing map in the upcoming election. So with that out of the way, Justice Alito goes on to discuss the merits issue in this case. He talks about the taint involved in the 2011 map. And he says, first of all, the legislature, here is referring to the 2013 legislature, there's a presumption of good faith involved in their actions. You presume that they're acting in good faith, and the burden is to show evidence that they're not. Now, the 2013 legislature didn't adopt the 2011 plan. Instead, they adopted this court-drawn plan that was designed to cure legal defects in the 2011 plan. So it's the 2013 legislature's intent that's relevant here. The 2011, the intent behind the 2011 map, the creation of the 2011 map, that's relevant toward inferring the intent in 2013, but he says that the record here is just not sufficient to show that there was bad faith by the 2013 legislature. He said the only direct evidence of the motives in 2013 was a desire to end prolonged litigation over these redistricting maps, and that was there was a legitimate motive by the legislature to want to put an end to that litigation. And so so he kind of resolves that issue like that. And then he goes on to talk about 4 specific districts that were challenged on other grounds, not challenged just because of the this invidious intent behind the 2011 map, but challenged because of specific problems with those districts. 3 of the districts were challenged under what's known as the effects test under the Voting Rights Act. And that's basically the idea is that the effect of a district is to basically dilute the power of the voting strength of a minority community. And he engages in kind of a fact-intensive examination of those districts, which I'm not going to go into here. And he concludes that there, in fact, was no Section 2 violation in those. Now, the 4th district, that one was challenged as a racial gerrymander. And that was when Latino and Black voters were deliberately drawn into a particular district. Texas had argued that they needed to do this to comply with Section 2 of the Voting Rights Act. That's that the effects test one. They thought they needed to do it to not dilute the voting strength of those minority communities. But Alito concludes that Texas failed to demonstrate that this was actually necessary to comply with the Voting Rights Act. So this was an impermissible racial gerrymander. So that's the majority in that case. Now, Justice Thomas had a concurrence, and in his concurrence, he restates, this is a view he's expressed in the past, he believes that the Voting Rights Act actually doesn't even apply to redistricting. And the language in the Voting Rights Act is that it deals with voting, it deals with things pertaining to voting qualifications or prerequisites to voting or standard practice or procedure. And he says that redistricting is not one of those things. It just doesn't fall into those categories. So because of that, the Voting Rights Act, compliance with the Voting Rights Act, can never be used to justify racial gerrymandering. So that's the argument that Alito rejected in this case. So Thomas agrees. He says the majority reaches the same result he would have, and the majority's opinion is consistent with the court's existing precedent. So he joins the majority, but he would go further and just say that the Voting Rights Act compliance can never be used to justify a racial gerrymander. Now, Justice Sotomayor wrote the dissent in this case. And she first argues on the jurisdictional point. She says that there was no jurisdiction in the Supreme Court. Now, the Supreme Court, in these 3-judge district court cases, the Supreme Court has mandatory appellate jurisdiction. That means it doesn't have a choice of whether to take these cases or not. If there's jurisdiction in these cases and somebody files an appeal, the court has to take that appeal. Now, she says that there's longstanding precedent in the Supreme Court that the court has to construe these type of appeals under the mandatory appellate jurisdiction narrowly, or else the court will be flooded with cases that it has no control over. And she says that she refers to a previous case that the court decided that involved redistricting, where the district court had left time for the state political branches to act rather than imposing an injunction, and the court held that there was no injunction, therefore there was no jurisdiction for the appeal. And she further argues that the other provision, 1292A1, the provision that allows for appeals to the Court of Appeals, she says the precedents allowing these practical injunctions, appeals on those, shouldn't apply because the Supreme Court's mandatory jurisdiction is just a different context. It's an exceptional context. There's no general right to appeal to the Supreme Court. And so the court shouldn't just carry that rule over. And she says here there was no evidence that the district court was manipulating his order or the order or evading Supreme Court review in some way. It's just the normal practice of district courts to separate the finding of a violation with the remedial phase, and that's what had been done here. And this appeal, in her view, was premature because there's important determinations about remediability that hadn't yet been decided by the district court. And she argues further that administrative simplicity, so bright line rules, so people know where a case can be, which courts have jurisdiction, that's essential to jurisdictional rules. And the court here kind of muddies it up by allowing these practical equivalents to injunctions. So then she goes on to talk about the merits issue about the discriminatory intent involved in these maps. And she says the district court did not shift the burden like the majority claims it did. Instead, the district court was applying correct legal standard. Now, Justice Sotomayor kind of reviews the history of this map of the legislature's districting process in some detail. And she accuses the majority of not giving proper deference to the district court's factual determinations. The district court is supposed to, there's supposed to be a great degree of deference to district court factual findings. The Supreme Court is only supposed to overturn them if they're clearly erroneous. And even if there is, if the district court applied the wrong legal standard, so if the district court had in fact shifted the burden impermissibly from what it should have been, the correct remedy should be to remand the case back to the district court to have it decided under the correct standard. And so she complains the court failed to do that here. Now she argues that the history shows and the district court's decision defects in the 2011 map that were carried over into the 2012 interim map, and the 2013 legislature was aware of those defects, but just took no. And also that in adopting the 2012 interim map, the district court had explained that its analysis had been expedited, it was curtailed, it had only made preliminary conclusions, and it might revisit those conclusions later. So she's basically saying the 2013 legislature had no reason to think that that 2012 map had cured all the problems, or that it should insulate them from things that were impermissibly done in the 2011 map. And then she goes on. So after concluding that's about the map issue, the 2011-2013 map issue, she goes on to discuss the individual districts, and she engages in her own fact-intensive analysis of the 3 districts challenged under the effects test, and again accuses the majority of not giving appropriate deference to district court fact findings, and she would have found that all of them were violations of the Voting Rights Act. She doesn't address the 4th district where the majority found the racial gerrymandering. Presumably, she agrees with the court's finding in that particular district. So that moves me on to the next case I'm going to discuss, and this is a case called National Institute of Family and Life Advocates, or NIFLA for short, v. Becerra. And again, this is our 3rd case that's a 5-4 conservative-liberal split. This time, Justice Thomas wrote the majority opinion for the conservatives. Justice Kennedy also wrote a concurrence joined by Chief Justice Roberts and Justices Alito and Gorsuch. And Justice Breyer wrote a dissent for the 4 liberal justices. Now, this is a case about it's a First Amendment challenge to California's FACT Act. And the FACT Act is a California law that imposes certain disclosure requirements on things that are known as crisis pregnancy centers. And these are pro-life centers that, among other things, counsel women about alternatives to abortion. Now, there are 2 categories of these centers that are involved in this litigation and in the California's FACT Act. There's what are referred to as licensed clinics and unlicensed clinics. Now, the licensed clinics are actual medical facilities. They provide various services, including prenatal medical care, pregnancy testing, prenatal vitamins, ultrasound examinations, other clinical services like that. Notably, these crisis pregnancy centers, they don't provide contraception or abortion-related services. Then the other category, these unlicensed clinics, they provide over-the-counter pregnancy test kits, maternity clothing, baby supplies, parental education programs, things like that. But they don't provide medical services that need a licensed medical provider to provide. So those are the 2 categories of centers. Now, California's Reproductive Fact Act has 2 separate disclosure requirements applying to these different types of centers. The requirement for the licensed clinics is they have to have a disclosure, and this is the language of the disclosure. Quote, California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women. To determine whether you qualify, contact the county social services office at, and then a phone number for the appropriate county. And this disclosure has to either be provided to patients directly or posted conspicuously in large type in the waiting room. And so the the crisis pregnancy centers object to this because they say they're being forced to basically advertise abortion services, which go directly counter to their mission and the whole purpose for these pregnancy centers to exist. Now, the unlicensed centers have a different requirement. They're required to have a disclaimer that says, quote, "The facility is not licensed as a medical facility by the state of California and has no licensed medical provider who provides or directly supervises the provision of services." And this has to be posted in several places, and it also has to be included on any advertisement that the crisis pregnancy center has, and it has to be included in a large a type size that's equal to the type size of the other language on the advertisement, and it has to be in what are called threshold languages. So those are languages spoken by a certain significant number of people, which varies by county, but it could be up to 13 different languages in Los Angeles County. Now, that's the basic idea of the requirements imposed by the FACT Act on these two different types of clinics. And another fact that was that comes up that was highlighted by the challengers to this was that there was exemptions for certain other types of facilities, notably facilities that participate in California's what's called the Family Pact program. And that California participation in that program requires the provision of contraceptive services. So the argument is that this, by exempting those facilities, it effectively only included the pro-life centers under the coverage of this these disclosure requirements. So Justice Thomas wrote the majority opinion, and he says he starts with dealing with the licensed facilities, and he says this compelled notice, the notice they have to post about the availability of abortion services, is a type of it's a compelled speech, and it's a type of what he classifies as content-based speech regulation. And the first thing he does is he rejects the idea that there's a special category for purposes of First Amendment case law, a special category for professional speech. He says that this should just, there's no special category that gets a lesser protection just because something is professional speech. Now, he says there's a few categories of speech that by professionals that gets a more deferential treatment, but it's only certain very specific types of professional speech. One is what he calls the disclosure of factual, non-controversial information in commercial speech. And that's something that comes from a case called Zouderer. It's referred to as the Zouderer standard. And he says that's limited to purely factual and uncontroversial information about terms of service. So the terms related to the services actually being provided. But he says here, the notice doesn't relate to the services the clinics actually perform. They give these prenatal type services. They don't perform abortions, so the notice isn't related to that. It's about separate state services that the state wants to provide. And then he goes on, the second category is the regulation of professional conduct that incidentally burdens speech. And that is Justice Thomas Class's informed consent laws under this, and these informed consent laws include ones related to abortion, and these that were upheld in the Supreme Court case Planned Parenthood v. Casey. Among the regulations that were at issue in that case were informed consent type requirements that required doctors to provide certain information to patients that were going to have abortions. And he says that these are justified as a requirement to give information about a procedure that's going to be performed. They're justified as part of the general practice of medicine. But here, the notices involved aren't tied to any particular medical procedure being performed. But he says, besides those special categories, professional speech is otherwise just protected First Amendment speech. This prevents the government from engaging in viewpoint suppression. It's important. He says candor is important in professional relationships, and this protects the marketplace of ideas to allow competing conceptions of what's the right thing to do or the right speech. And he also says that a limitation based on professional speech would be difficult to cabin. It could range it's hard to draw a line around that. And in various lower court cases, a huge range of different jobs have been treated as professional speech and given lesser protection. And this includes not only doctors and lawyers and nurses, but also truck drivers, bartenders, and barbers have been classed as professionals for purposes of giving them a lesser protection. And so Justice Thomas says that this is just there's no there's no good it's difficult line drawing or hard to cabinet to narrow class. So he says that the disclosure requirement here has to fail. He says the stated interest of the state is to provide low-income women with information about state-sponsored services. But he says here it's wildly under-inclusive. He says that the requirements, they don't cover any of the nearly 1,000 community clinics that deal with low-income individuals. It doesn't cover federal clinics or any of the California Family Pact providers. So the under-inclusiveness, he says, under the court's First Amendment precedents, it raises doubts about the stated interest. And he says that the state didn't consider alternatives, like, for example, a public information campaign, and California provided no evidence that this would be ineffective. So he finds that the standard is the challengers are likely to succeed on the merits. That's the standard. This came to the Supreme Court as a preliminary injunction. The challengers were seeking a preliminary injunction to block the enforcement of this the FACT Act disclosure requirements. And so he finds that they've met their burden of that they're likely to succeed on the merits, so are entitled to an injunction. So then he goes on to deal with the unlicensed clinics and the notice they have to provide. And he says, assuming that this falls under the Zouderer standards, so that's the providing non-controversial factual information. He says even under that standard, disclosure requirements can't be unjustified or unduly burdensome. They have to address a real harm. They can't be broader than are reasonably necessary. And he says California's justification here was to ensure that pregnant women know that they're not dealing with licensed professionals. But he says California has provided no evidence that this lack of understanding exists. He says that some of the services that trigger being covered by this notice requirement include things like having volunteers who collect health information, advertising for pregnancy options counseling, and offering over-the-counter pregnancy testing. And he says things like these are not things that someone would expect to be necessarily provided by a licensed medical professional. So California hasn't adequately shown that this justification is needed in this context. He said that this would be likely to the plaintiffs, the challengers in this case, are likely to succeed in defeating California's justification here, though he leaves it open for California to provide more evidence as the case goes forward. He also talks about the undue burden, that this is unduly burdensome. He says the fact that it exempts unlicensed providers of contraceptives makes this suspect. So clinics that provide contraceptives are exempted from this, and speaker-based laws, he says, they're suspect because they suggest that that the favored speakers are being left unburdened to deliberately impose this increased burden on the disfavored speakers. And he also talks about the advertising requirements, which require a 29-word verbatim statement in the same or larger type as the ad language, and up to 13 languages depending on the county, and just says that this is extremely burdensome. He expresses no view on a similar disclosure that's better supported by evidence or less burdensome. But he thinks that the preliminary injunction should be imposed here. Now, Justice Kennedy had a concurrence in this case. He joined the majority in full, but also had a concurrence, and he addresses first what he views as the apparent viewpoint discrimination involved in this case. He says that the argument wasn't fully developed here, so he agrees that not to decide it in this case, but he says that it raises a serious constitutional concern. And here's a few quotes. He says, quote, "The state requires primarily pro-life pregnancy centers to promote the state's own preferred message advertising abortions." And further later he says, quote, "The history of the Act's passage and its under-inclusive application suggests a real possibility that these individuals were targeted because of their beliefs." And he specifically he's very critical of language used by the state in enacting this act, saying that it was a forward-thinking piece of legislation. And he responds to that saying, quote, "It is not forward-thinking to force individuals to be an instrument for fostering public adherence to an ideological point of view they find unacceptable." And he goes on to say, quote, "Governments must not be allowed to force persons to express a message contrary to their deepest convictions. Freedom of speech secures freedom of thought and belief. This law imperils those liberties." So he writes, it's relatively short, but a very kind of strident First Amendment opinion, concurring with the majority. So that brings me to the dissent, and this is by Justice Breyer. Now, Justice Breyer criticizes the majority's characterization of the disclosure as content-based speech regulation. He says that this is just too broad. If you took that literally, virtually every disclosure law everywhere would be a content-based speech regulation subject to this extremely high First Amendment standard. And many of those very common types of disclosure requirements wouldn't fall within the exceptions that the majority discussed about speech that's related to provision of goods or services. And he gives examples, for example, of hospitals being required to give certain health and safety disclosures to parents related to the care of newborn infants, where it doesn't specifically relate to any procedure that the hospital was providing, and also certain in various other contexts, like disclosures landlords have to give to certain tenants and things like that. And he says that the majority's exception for, quote, "health and safety warnings long considered permissible or purely factual and uncontroversial disclosures about commercial products," he says that's just going to ask for litigation because it's so unclear what falls in that and what fits within that category. But he says this shouldn't be lumped in with the court's case law on content-based speech regulation, because disclosures don't normally limit speech. They require someone to disclose certain information, but they don't actually limit someone's speech, so they shouldn't be regarded the same way as a speech limitation. Now, he spends a while specifically talking about Planned Parenthood v. Casey. That's a 1992 abortion case. That was a follow-on case after Roe v. Wade that kind of refined and changed the standard for evaluating abortion restrictions. But in that case, the court upheld a law that required doctors to tell, here's a quote, "to tell the woman about the nature of the abortion procedure, the health risks of abortion and of childbirth, the probable gestation age of the unborn child, and the availability of printed materials describing the fetus, medical assistance for childbirth, potential child support, and the agencies that would provide adoption services or other alternatives to abortion." So the court in that case upheld that large set of disclosures that doctors were required to give women who were seeking abortions, and found that there was no undue burden on women seeking abortions. And in that case, the court denied that there was any First Amendment concern, any violation of the First Amendment concern in requiring that kind of disclosure. And so Breyer says an even-handed application of this Casey standard should easily justify the disclosure here. These licensed clinics are medical professionals who are providing pregnancy-related services. So, and the disclosure in this case is just as valuable as the informed consent in the Casey case. He also disagrees with the majority in saying that the disclosure is not related to medical procedure. He says the childbirth itself, and that's the services people are going to, are services related to childbirth. Childbirth itself has medical risks, and disclosures often go beyond just the narrow procedure being performed. For example, and he refers to an example of a law, a state law involving breast cancer screenings, where if there's a finding of breast cancer, the professionals providing the screening are required to give a disclosure of treatment options. Now, that disclosure has nothing to do with risks of the screening itself. It's about what was discovered in the screening. Yet that's a pretty standard type of disclosure that Justice Breyer says should be perfectly reasonable and acceptable. He also hits a few other points. He says that targeting centers that cater to low-income individuals is reasonable. So some of the line drawing involved in the state and not pulling in a lot of the paid clinics is not an issue here. He says that the Zouderer standard, notice that the state provides certain services in the same area, that's a perfectly factual statement, and it's an interest that the state has in providing, and that should meet that standard. And he says that because these disclosure laws don't prohibit any speech, that the court just shouldn't rely on cases that are about speech restrictions. They're not really applicable. And he also talks about the discussion of factual, non-controversial information that the majority mentioned, and he said here the availability of abortion services is factual, not a normative statement. It's just it's a fact of what California provides, and he says that the disclosure here, it doesn't express a preference for abortion over alternatives, and he says that this regardless of the normative disagreements that exist over abortion itself, he says, in fact, that this moral disagreement over the status of abortion makes the even-handed application of this doctrine even more important in this area. So he argues that in supporting his argument that the prior case law, including Casey, should be applied even-handedly in this case. He also addresses the viewpoint discrimination issue, and he says that wasn't really fully developed in the court below. I can't support a preliminary injunction for that reason, but he suggests that could be a viable claim if the facts supported it going forward. So presumably he would have, he's in the dissent here, but he would have allowed that claim to be further developed. Not for the preliminary injunction, but for later purposes as the litigation went along. So moving on, he talks about the unlicensed clinics. And he says, quote, "It is self-evident that patients might think they're receiving qualified medical care when they enter facilities that collect health information, perform obstetric ultrasounds or sonograms, diagnose pregnancy, and provide counseling about pregnancy options or other prenatal care." So he's countering the argument that California hadn't shown that there was this interest in providing the disclosure that it was a non-licensed clinic, and he also says that there's no evidence in these cases of viewpoint discrimination. He says the exclusion of providers of contraceptive services is reasonable because the intent here was to protect pregnant women from unlicensed, unknowingly going to unlicensed providers, and contraceptive services are not typically used by pregnant women, so that exclusion was sensible based on the goal here. And then he says that there isn't an undue burden shown here. The burdens are all hypothetical, and he says that really the things like the advertising, the concern over the large type and 13 different languages, that should be addressed in a case-by-case manner. He says in the vast majority of counties, the disclosure is actually needed in only 2 languages. If the burden of 13 languages in LA County is really that significant, that could be challenged in an appropriate case on a case-by-case basis. So that brings me to the end of that, and then move on to our next case. This is the other case that was issued Tuesday, which is Trump v. Hawaii. This was the travel ban litigation, the case over the Trump administration's ban on entry into the country from nationals from certain countries. And again, this is our 4th case we've discussed tonight that split 5-4 along the conservative liberal lines. Now, some very brief background about the travel ban litigation. There were 3 separate versions of the travel ban that went into effect at various times. The first one was issued only a week after President Trump's inauguration. That was later an amended executive order was issued a little more than a month later that made various changes to the original one. And then those original orders had a 90-day entry ban, and also called for the various parts of the administration to conduct a global review of the immigration procedures to vetting procedures, and determine after that how to go forward. Eventually, when that travel ban went into effect and that 90-day period happened, the government conducted a review, and at the conclusion of that review, version 3 of the travel ban was enacted. And that happened this past September, the version 3. Now, this one was not a temporary one. It wasn't a 90-day ban. This was a permanent or a continuing ban. it changed, it dropped or modified the countries that were involved in the ban from the previous version, and required a review every 180 days of the inclusion of countries in that entry ban. Now, several arguments were made challenging this ban. There were the entry ban. There were challenges made on statutory grounds. There were both that the president did not have the authority to issue this order, or that in issuing this order, it conflicted with prohibitions in another statutory provision, and I'll discuss those in a minute. But there was also a constitutional challenge saying that this was a violation of the First Amendment's Establishment Clause, and that's a prohibition on the establishment of religion, that the idea that the government can't favor one religion over another. And the basic claim here is that the implementation of this travel ban was infected by anti-Muslim animus, that it was enacted for these discriminatory purposes. And thus, therefore, it's impermissible and should be struck down as a violation of the Establishment Clause. So those are the basic issues in the case. Now, it was a 5-4 split. Justice Roberts wrote the majority for the 5 conservatives. There were also concurrences, solo concurrences by Justice Kennedy and Justice Thomas. And Justice Breyer, there were 2 separate dissents, and the dissents were split. There was one dissent by Justice Breyer, joined by Justice Kagan, and a second dissent by Justice Sotomayor, joined by Justice Ginsburg. And so let me run through each of the opinions to kind of explain the breakdown and where the different justices fell in this. So Justice Roberts, he began his opinion with kind of a procedural history of the different presidential executive orders and the final proclamation that was version 3 of the travel ban, and the litigation over the travel ban at various stages. And he also gives kind of a review of the review procedure under the executive orders that the executive branch was supposed to enter into in order to evaluate the various countries of the world for purposes of designing its immigration policy going forward. And he briefly touches on a concept known as consular non-reviewability, and this is an idea that from some of the court's older cases, saying that the exclusion of an alien from the country is simply not reviewable by courts unless there's an express authorization by law of such a review. And there had been arguments made that should apply here, and basically this entire travel ban should be non-reviewable. The courts just can't review it. But Justice Roberts says that that's not a jurisdictional requirement. So for purposes of this case, they're not answering that question, but just assuming reviewability for purposes of this opinion. And he goes on to discuss first the statutory arguments. Now, there's a provision. The first provision is a provision of the Immigration Act that's Section 1182F, which says the president can, quote, suspend the entry of all aliens or any class of aliens whenever he finds that their entry would, quote, would be detrimental to the interests of the United States. So he says this is a very broad deferential authority given to the president. And he says the proclamation here satisfies this requirement of finding that the entry would be detrimental to the interests of the United States. And he says, in fact, this proclamation was more detailed than any of the previous presidential uses of this this provision, 1182F. And apparently there have been 43 prior suspensions before this by various different presidents. And he says this is the most detailed one that's ever been given under this provision. So the idea that an insufficient explanation was given, he says, does not hold up. There was also an argument made that the requirement that he can suspend for such period, he can suspend their entry for such period. There was an argument that required a defined period of time, and the fact that this had no fixed end date meant it violated his authority. And Justice Chief Justice Roberts just simply rejects that, says that there's no requirement by saying it can be for such period that there's no requirement that has to include some kind of fixed end date, and that wouldn't make sense, especially if this is dealing with national security emergencies or things like that, where the specific time frame involved wouldn't necessarily be known ahead of time. If there's a war starting or something like that, and no one knows how long it's going to last. And he also notes that in the 43 prior suspensions under this provision, not a single one of them had a fixed end date involved. So he rejects that idea. And he says that, in fact, here the proclamation says that these restrictions are conditional. They're by the terms of the proclamation, they are only supposed to remain in place as long as needed, and it has these 180-day reassessments built into it. And he further says that this provision applies to any class of aliens, and he says this is broad enough to include nationality. A class of aliens is just a very, very broad provision that the president can designate, and so that could include nationals of a certain country. He goes on to say that he finds this to be consistent with other provisions of immigration law. Two in specific have been highlighted. One is the individualized vetting system that exists to review individuals from other countries that want visas into the United States, and the other one is what's known as the Visa Waiver Program. And this is a fast track program where nationals of certain countries, certain cooperating countries, have a faster processing and faster admission into the country. And what he says is, Justice Roberts says, there's no identified conflict between the proclamation and either of these programs. There is an individual vetting system, but there's nothing that requires vetting to occur only on a one-by-one basis. The proclamation is intended to deal with systemic problems concerned with unreliable documentation from certain countries. And so there's nothing inconsistent by having those two different types of vetting. One kind of country-wide rules to deal with these systemic problems, and individualized vetting to look at individuals of concern. And then he also says that this proclamation actually works in tandem with the Visa Waiver Program. He says the Visa Waiver Program gives this special status to the top 20% of countries, but the remainder of countries are undifferentiated, and this proclamation just says the very bottom countries, those countries that are kind of in worst compliance with good verification and cooperation with the United States, they're being treated as a separate lower category, and there's nothing inconsistent about that. There's also an argument that this provision should be an argument based on the legislative history of this provision, saying that it ought to be construed to be limited to emergencies, so limited to only dealing with national security emergencies. But Justice Roberts argues that, in fact, language that would have limited to national emergencies was explicitly removed during the drafting, and it's been used by past presidents for broad purposes, including as a political tool to kind of push back against countries that were adopting policies unfriendly to the United States. So he says that this is within the president's authority under 1182F. So that brings me to the second provision, and this is a section called 1152A1A. And this provision says, quote, "No person shall be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence." And so, again, this prohibits discrimination against the issuance of an immigrant visa because of, among other things, nationality. So there's a challenge that regardless of the general authority the president has under the other provision, he should be barred in discriminating on the basis of nationality by this provision. Now, Roberts first points out that this is limited to the issuance of immigrant visas. So first of all, there's no application of this to non-immigrant visa categories. So he just notes that limited application here. So at most, this would prohibit part of what's covered by the proclamation, not the entirety of it. But then he goes on to say that this ignores a distinction between visa issuance and admission. He says admissibility has two roles in the basic process. First, when there's if an inadmissibility determination has been made about some individual, then that makes that individual ineligible for a visa to receive a visa. One of the criteria needed for obtaining a visa is admissibility, so that would make them ineligible. But then even if someone has been granted a visa, inadmissibility can still bar entry. So someone can be granted a visa and then arrive at the United States and be barred entry because they're determined at some point to be inadmissible. So the inadmissibility has those two roles in the process, and they're separate and distinct from the issuance of a visa. And he says that you can reasonably read these provisions together to say that the president has this broad authority to determine that certain classes of people are inadmissible. But once you've passed that point and people are admissible, when making determinations of who does and does not get visas, you can't make any of these discriminatory determinations. So he says that it fits together, and you can read these together. And he also points to other provisions of immigration law that expressly prohibit exclusion from the country or restrictions on entry, rather than speaking in terms of visa issuance. So if this provision were intended to apply directly to exclusion or restrictions on entry, it would have been phrased in that way and not phrased in terms of visa issuance. So that with the statutory arguments out of the way, he moves on to the constitutional argument about anti-Muslim animus. And he says that there is standing to bring this challenge by some of the challengers in this case, based on exclusion of people's relatives from the country. And he goes on to kind of recount some of the history here. He recounts President Trump first as a candidate and then later as president, some of his more inflammatory statements about Muslims. But Chief Justice Roberts, he frames this as an issue of the significance of these statements on an otherwise neutral enactment. And he refers to an older Supreme Court case called Kleindienst v. Mandel. And in that case, the court found that its reviewing the admission admissibility, or whether the admission to the country, the court's review is limited to whether the government has provided a facially legitimate and bona fide reason. And this is justified in part by national security concerns and about having the courts play too much of a role in second guessing the government's actions. And he says here, under that test, he says there was a legitimate purpose. It's preventing the entry of nationals who can't be adequately vetted, and also to induce nations to improve their practices. And he says that it's facially neutral. He says there's no mention in this proclamation of religion. It's true that 5 of the 7 nations that are included in the final proclamation are Muslim majority nations, but only 8% of these nations make up only 8% of the world's Muslim population. So it's not targeting Muslims in the whole. It's just targeting those who live in these particular countries that are targeted. And he says further that the proclamation gives an explanation for the inclusion of each nation on the list. So there is justification that's been provided by the government. And he gives a couple other facts that he says support the finding that there's a valid national security interest. One is that since the first version of this travel ban, the first executive order, there have been 3 Muslim majority nations have been removed from the list. And those are Chad, Iraq, and Sudan. And also that apparently that Libya, according to the State Department, is involved in ongoing engagements with the United States to improve its practices. And presumably, if those improvements did occur, would be removed from a future version of this list. And he says that another factor is that each of the countries on the list, there are significant exceptions made for various categories of immigrants entrants from those countries. For example, from some countries, students are allowed in, and many non-immigrant visa types of non-immigrant visas are allowed from many of the countries on the list. And because of these carve-outs, he says it effectively exempts the majority of visas sought in years prior to this enactment. The majority of those visas actually fall within some of these exempt categories. So the fact that all these exemptions are made for these certain categories on a country by country basis undermines the idea that it's just purely a Muslim ban. He also says that there points to a waiver process that exists for immigrants who can show undue hardship from the ban, and so he points to those to show that this that there's at least support for this having a national security rationale. So as a result, the order here is that the lower court's injunctions are reversed. This is remanded to the lower courts for further proceedings to go forward, but there's no preliminary injunction in place, and the travel ban can be in full effect. Now, Justice Kennedy concurred at a short statement. Now, he joined the majority opinion in full, but also had a short statement basically just noting the duty of government actors to obey the Constitution's anti-discrimination requirements, even in circumstances where their actions may be unreviewable in court. So he's kind of recognizing the fact that the court's doctrines that they're adopting may result in certain actions being effectively unreviewable, but then kind of impressing on the officers in the executive branch their duty to make sure that they're still acting constitutionally. Just an interesting short statement there. And then Justice Thomas also had a concurrence, and he states very briefly a few broader positions that he holds, and this is kind of common thing for Justice Thomas, where he has some very idiosyncratic views that are often very much broader than other members of the court. But he states a few of them very quickly. First, he argues that the president's authority is not limited to the statutory authority under sections 1182, but the president actually has inherent executive power to exclude aliens from the country, and he can use that executive power regardless of if it fits precisely within the scope of section 1182. He also, under the Establishment Clause, so the anti-Muslim animus part, he specifically rejects a particular test that is used in some Establishment Clause cases, which asks whether a reasonable observer would regard something as trying to favor a particular religion, and he rejects that reasonable observer test as not the appropriate test in this case. He doesn't elaborate more in this particular opinion. And then the third one is he argues that aliens abroad, so aliens not in the United States, basically don't have other constitutional rights, so aren't able to bring other potential constitutional claims because they just can't exercise those rights. But then the bulk of his concurrence is on a different subject, and this is something referred to as universal injunctions. And this is one of the issues that the court had said that it was considering in taking this case. It was one of the questions presented, one of the issues that the court might have resolved, but didn't actually in the majority opinion. And universal injunctions are it goes by several different terms. Sometimes they're called nationwide injunctions, sometimes universal injunctions. But it's the idea of that a district court in ruling in granting an injunction, so in granting an order to someone barring typically the government from going forward with some policy, instead of barring them from applying the policy to the particular parties to the case, the people bringing the legal challenge, the government is ordered to stop applying that policy nationwide to everyone. And so that happened in this case multiple times over the course of the litigation. District courts entered injunctions barring the federal government from enforcing the travel ban nationwide as to any entrance into the country. And Justice Thomas says that this practice of issuing these universal injunctions, first he says there's no statutory authority for this, and that the court's equitable power, the court's power to grant these orders as remedies for violations of the law, is constrained by historical practice. And he says that these universal injunctions are a very recent innovation. They first emerged in the 1960s and really only exploded within the last decade. Traditionally, American courts provided no relief beyond the parties to the case. Now, sometimes if it was necessary in order to give the parties to the case full relief, the crafted in a way that it benefited other third parties as well. So, for example, if someone is challenging a segregated school, in order to provide them with the integrated school, it would be necessary to have an injunction that would apply broadly to anyone involved in that. That's just an example. But the court is only supposed to be granting relief sufficient to benefit the parties that are actually in court in the case. And he says that this idea, it meshes with other doctrines that the courts apply, like the idea of standing, that you can't bring a legal claim on behalf of just harms to some other person. You have to have some personal stake, some personal harm to you in order to bring an action. Well, that meshes with the idea that the relief that the courts grant should also be limited to the parties that are before the court. And here's his conclusion. He says, quote, "In sum, universal injunctions are legally and historically dubious. If federal courts continue to issue them, this court is duty-bound to adjudicate their authority to do so. So he's basically flagging this as something he wants the court to address head on in a future case. So that brings me to the dissents, and I mentioned there's two of them. We'll start with Justice Breyer's dissent. Justice Breyer's dissent, joined by Justice Kagan, is pretty narrow. He says, the issue here is, was this proclamation significantly affected by religious animus or solely based on national security? And he says that to determine this, one way to ask this question is to look at the system of waivers and exemptions involved here. And he says that if there's these waivers and exemptions that are in place, if they're being applied faithfully, that would strengthen the legitimacy of this as a national security practice. He says it would be consistent with past presidential practices under previous proclamations, and he says it also kind of more closely matches the case-by-case framework of the immigration statutes more generally. But he says, on the other hand, a failure to provide these remedies or these waivers or exemptions as are called for in the proclamation makes this seem more like it's really just a Muslim ban in disguise. And then he looks at it, and he says, he raises a few things that he says weigh more toward the second determination, that this is really what he regards as a Muslim ban in other names. First is that apparently no guidelines for granting waivers have been promulgated to consular officers. So there are no standards have been given to them in order to do this. And there's also an affidavit has been produced in other litigation from a consular official saying that they have no authority to grant waivers. They haven't been allowed to actually grant these waivers. And preliminary data shows that there's basically a minuscule number of visas has been granted. And according to Breyer, according to the numbers, based on the number of visa applications prior to the travel ban being implemented, based on those prior years' data, the exempted categories of visas under the proclamation should have resulted in a significantly higher number of visas granted. Categories like students and refugees would have accounted for a significant number of visas, but the fact that such a tiny number of visas has actually been granted suggests that these exemptions are not actually being applied as they're supposed to be in the proclamation. And now Breyer acknowledges that these are just anecdotes and preliminary numbers. This isn't official judicial fact finding, but he says that there's enough there for the preliminary injunction to stay in place, and that this should have been remanded down for a fuller determination on this issue. So that brings me to the second dissent, and this is by Justice Sotomayor. And this dissent is a much kind of takes head on the anti-Muslim animus point, and she points to factors that normally under the court's case law, the court is supposed to consider when determining whether the government is acting in a way that disfavors a particular religion. And here's some of the factors. She says it includes the text of the government policy, its operation, and any available evidence regarding, quote, the historical background of the decision under challenge, the specific series of events leading to the enactment of official policy in question, and the legislative or administrative history, including contemporaneous statements made by the decision maker. And then she goes into kind of a much lengthier recounting of various statements by Trump. And she goes through a very lengthy kind of a catalog of all the various things Trump had said, both as a candidate and as president. And kind of emphasizes both the extent of his anti-Muslim statements, and also kind of shows kind of a continuity from his earliest statement regarding wanting a Muslim ban during the campaign, all the way through version 3 of the travel ban, the current version that's in place right now. And she concludes from this, says, viewed in totality, the proclamation was driven primarily by anti-Muslim animus. And she notes that there was never any disavowal of any of these statements by President Trump. And there she compares this to the recent Masterpiece Cake Shop case, in which the court ended up siding against the Colorado Civil Rights Commission on the basis of what the court viewed as anti or statements against the religious beliefs of the shop owner in that particular case, and says that same standard applied here should easily find that's anti-religious animus by President Trump. And then she goes on to criticize the majority's reliance on facial neutrality. She rejects what she characterizes as a rational basis approach. That's just referring to an approach that only asks whether the government has a legitimate interest and it doesn't dig too deeply into it. She says that the Establishment Clause, under this religious freedom provision, it demands a more searching probe. And she says here there's overwhelming evidence of anti-Muslim animus, and that should defeat any suggestion of a legitimate purpose. And she also says that this proclamation, she characterizes it as, quote, religious gerrymander, a religious gerrymander. She says that it targets Muslim majority nations. It has this minimal inclusion of 2 non-Muslim nations, that's Venezuela and North Korea, but basically suggests that's just kind of for cover. It only applies to a handful of high-ranking Venezuelan officials, and North Korea was already subject to restrictions due to sanctions, so it didn't really have much application to either of those. This is really just targeting a bunch of Muslim majority nations. And she says that the proclamation as issued doesn't really mesh well with the worldwide review that supposedly justifies it. She said, first of all, that the results of that worldwide review are secret, so the court is unable to really evaluate them. But according to a Freedom of Information Act request, the report that was produced based on this process was only 17 pages long, which she regards as just facially insufficient to justify a policy of this type. And she says that the national security concerns that are supposedly behind this are already addressed by the statutory scheme through the individualized vetting and the visa waiver program. And she furthermore, citing Justice Breyer's dissent, she says that she regards the waiver process as a sham. So based on all of this, she says this satisfies the standard for a preliminary injunction, and it should be issued. Now, she also concludes with some very strong language. She has a strongly worded final statement. She says, quote, in holding that the First Amendment gives way to an executive policy that a reasonable observer would view as motivated by animus against Muslims, the majority opinion upends this court's precedent, repeats tragic mistakes of the past, and denies countless individuals the fundamental right of religious liberty. And then she goes on to have a pretty lengthy comparison of this decision to a case called Korematsu v. United States, a 1944 case. Now, that's the notorious Supreme Court decision that upheld the internment of U.S. citizens of Japanese ancestry during World War II. She has kind of a lengthy comparison, basically saying that the court is deferring to a supposed national security rationale when it's clear that there are actually invidious, discriminatory motives that are really motivating the policy. And she concludes, this is her final line of the dissent. She says, quote, our Constitution demands and our country deserves a judiciary willing to hold the coordinate branches to account when they defy our most sacred legal commitments. Because the court's decision today has failed in that respect, with profound regret, I dissent. So that finishes our discussion of Trump v. Hawaii. We've got 2 cases left to go. Now, the first of these 2, I'm going to try and move through very quickly. This is a case called Florida v. Georgia. This is the only one of the 6 cases this week that did not divide along the ideological lines, now, though it was still a 5-4 decision. This had a majority written by Justice Breyer, joined by Justices Kennedy, Chief Justice Roberts, Ginsburg, and Sotomayor, and Justice Thomas in dissent, joined by Justices Alito, Kagan, and Gorsuch. And this is, we've had a lot of these very high-profile, politically divisive cases that split along ideological lines. This is pretty far from that. This is a highly technical, highly detailed case, and it's about water rights. And so let me briefly talk about this. I'm going to try and run through it pretty quickly. It's a dispute over the allocation of water in the Apalachicola, Chattahoochee, Flint River Basin. and which covers parts of Alabama, Georgia, and Florida. And the specific issue is this: there are two rivers, the Chattahoochee River and the Flint River, that come together and become the Apalachicola River, which flows down through Florida. And Florida brought this action against Georgia, alleging that Georgia's overuse of water in the river system was causing ecological and economic harm to Florida. So when there's drought situations, because Georgia was taking too much water, Florida was suffering from the drought conditions. Now, an important fact in this case is that the Army Corps of Engineers operates a set of dams and reservoirs on this river system, and those dams and reservoirs, to some degree, determine the flow of water on various parts of the river. And specifically, there's the water flows into a lake. The water coming from Georgia flows into a lake, and then from that lake, water is released downstream to flow down into Florida. And there's also a series of other dams on one of the two rivers further up. Now, the result of this case, the issue in this case was so let me back up a second. This is a case in the court's original jurisdiction. Now, these are those narrow set of cases that are not appeals to the Supreme Court, but are cases that are filed directly in the Supreme Court. And the most common category of these cases are suits by one state directly against another state. So here, Florida v. Georgia. And the most common reason for these suits is water disputes. So this is a recurring situation the court has to deal with whenever there's rivers flowing over state lines. There's often these disputes over who's one state using more than their fair share and typically depriving the downstream state of its fair share of the water. Now, the way the court deals with these cases, the court is not. It's an appellate court. It's not a trial court. It's not set up to hold trials, to hear testimony, things like that. So what it typically does in these cases is it appoints a special master. The special master will hear the case. The special master essentially acts as a trial judge in the case, and hears testimony, may hold a full trial, and eventually issues a report. Now, that special master's report is like a judicial opinion, and that judicial opinion, the parties to the case have the opportunity to make what's known as exceptions. That's kind of objections to aspects of the report. So they file exceptions to the report, and then the Supreme Court reviews those exceptions, and the Supreme Court can choose to overrule or sustain those exceptions and modify the special master's report, or they can adopt the special master's report or adopt it with certain modifications or whatever. But the Supreme Court essentially converts it into more of an appeal by allowing the special master to serve as the trial court, and the Supreme Court sits in review over the report from the special master. So here, the special master determined that although Florida was harmed by Georgia's overuse of water from the river system, the issue here was if Georgia were ordered to stop using the water that it was using, if it was ordered to do that, any additional water that was flowing downstream in there would be flowing into these lakes and reservoirs controlled by the Army Corps of Engineers. And because of the Army Corps of Engineers, the Army Corps has a kind of a large number of criteria it uses for controlling the flow of water through these river systems, and includes various considerations about flood control, but also about the Endangered Species Act and ensuring that there's appropriate water levels in various places, and also planning ahead and trying to reserve water in various reservoirs, lakes and reservoirs, to be able to accommodate future drought conditions. And so the fact that Georgia allows more water to flow downstream does not necessarily mean that that water will end up in Florida, because that water may end up, or at least not end up in Florida immediately, not end up right when it's needed. That water may end up, because more water is coming in from one river, for example, the Army Corps may choose to dam more water, hold more water back in reservoirs in the other of the river systems, so the same amount of water may come down to Florida. The Army Corps may choose to not allow more water to flow through because it's trying to build up its reserves in the reservoirs so that there's more for the future. There's various considerations. So the issue was, the special master ruled that Florida hadn't proven that, and importantly, the Army Corps of Engineers was not a party to this case. The United States did not agree to be a party to this case, and they were immune from being pulled into it. And the Army Corps of Engineers was not, the court was not in a position that they could order the Army Corps of Engineers to do anything or change its practices here. And so the court, the special master held that Florida hadn't proven that it would actually benefit from Georgia reducing its water use, because it hadn't shown that the water would actually end up making its way to Florida. Now, Justice Breyer writes the opinion for the majority, and the end result here is he wants to remand this case back to the special master for further factual findings and further proceedings. And the issue here is, this is a case that's under what's known as equitable apportionment, and that's the court's doctrines that have built up over the years for trying to allocate water between different states. And the argument here was basically that the special master applied too strict of a standard. He said that while the state that's complaining, so here Florida, has a high burden of showing that they've been harmed, showing that there's an actual harm here from Georgia, they don't have such a high burden in demonstrating the remedy. The court says, in fact, these remedies, the solution in these cases, it doesn't demand precision or being able to know the future with certainty. The courts have a lot of leeway in crafting an appropriate solution going forward. And as long as if Florida had met its burden of showing that it was harmed and that harm was caused by Georgia, then the fact that they couldn't meet a particularly high standard of demonstrating that the remedy would help them, that's not enough, and this should go back for further determinations. And this is how Breyer kind of characterizes it. He kind of splits it up into different questions involved in this case. First, did Georgia harm Florida by taking too much water? He says basically yes. The special master determined yes. Would a cap on Georgia's use increase the flow to Florida? That's the key question that's at issue here in the appeal. And he says then a further question is, would increased flow from coming to Florida if a cap on Georgia's use would increase the flow to Florida, would that be enough to actually help Florida? Would it actually solve the economic and ecological problems? He says, well, that's a question for the special master to look at on remand. But the main question here is, would a cap on Georgia's use increase the flow to Florida? And he says that the evidence suggests that the Army Corps would be likely to release additional water to Florida. And he includes in this a lengthy technical discussion of the Army Corps' management practices of the river system. But he says that the case should be remanded to the special master for more fact-finding on the amount of benefit to Florida. And he notes that the Army Corps had indicated that it'll take into account any decree from this court, and it will be cooperative, but that the Corps does have many competing priorities. At the end, Justice Breyer, in saying that this should be sent back to the special master for more fact-finding, he goes through a number of additional questions that the special master should consider and maybe answer in this additional fact-finding. And I'll just run through those just to kind of show how much Justice Breyer thinks is still needs to be determined. He says, quote, "To what extent does Georgia take too much water from the Flint River? To what extent has Florida sustained injuries as a result? To what extent would a cap on Georgia's water consumption increase the amount of water that flows from the Flint River into Lake Seminole? To what extent, under the Corps' revised master manual or under reasonable modifications that could be made to that manual, would additional water resulting from a cap on Georgia's water consumption result in additional stream flow in the Apalachicola River? To what extent would that additional stream flow into the Apalachicola River ameliorate Florida's injuries?" So, I mean, that's pretty much the entire case that Justice Breyer is suggesting needs more fact-finding and determinations from the special master. So that brings me to Justice Thomas's dissent. Now, Justice Thomas emphasizes at a few points in this dissent how much fact-finding has already happened at the special master, in front of the special master. He mentions there was a 1-month trial that involved 40 witnesses and more than 2,000 exhibits. And he later talks about all of the discovery, so the document production and such that happened. He says, during their 18 months of discovery, the parties produced 7.2 million pages of documents, served 130 third-party subpoenas, issued more than 30 expert reports, and conducted nearly 100 depositions, including 29 expert depositions. So he's emphasizing the extent of the proceedings that have already happened here. And then he goes through his own discussion of the Army Corps' practices managing the water on this river system. And he notes that the Army Corps maintains a relatively steady flow of water out of Lake Seminole, and that's where the water that comes down to the Apalachicola River into Florida would come from. And he says that basically the Army Corps has a preference for reserving water in its reservoirs, and its normal policies wouldn't result in much additional water during drought periods if Georgia were to allow more water to flow downstream. And he says that in this case, the special master correctly applied the tests in this case. He says the majority misconstrues the special master as dealing with a threshold determination, as thinking that the special master was requiring Florida to have to demonstrate this remedy at the outset. But he says, in fact, no, the special master was correctly dealing with this at the appropriate point in the process, conducting what's known as a balance of harms test. And one of the threshold questions in this balance of harms test is that Florida has to show that there would be some appreciable benefit, and that's where Florida had failed. And he says the approach that the majority is taking would require these numerous factual determinations early on before determining even if Florida would see any appreciable benefit, and that just is unnecessary to require all of that up front. And so Justice Thomas thinks a remand is inappropriate. He says that this court the special master is doing all this work, but this court is supposed to also use has the final say and is supposed to do its own independent evaluation. And he says that the evidence shows that Florida failed to prove its case. The United States represented consistently through the litigation that it typically wouldn't increase the flow that goes to Florida. The outflow from the Lake Seminole is unrelated to the inflow. Instead, it's driven by the need to store water up for Endangered Species Act purposes. He points to models that were introduced, expert models that showed that that under the Corps' current procedures, had this Georgia allowed additional water in recent years, it would have resulted in increased flow on only very limited days during the drought season. And also, he says that arguments that the Corps might increase the flow voluntarily are purely speculative. The last time the Corps updated its manual to change its water management practices, it led to 2 decades of litigation, and an older policy that the Corps had that resulted in increased water flow downstream led to disastrous situations where the Corps had extremely low reserves and not enough to fulfill its necessary functions. So he says that Florida just can't demonstrate any benefit from an increased water flow during if Florida might get additional water during non-drought periods, but can't show that actually benefits it any. It already has plentiful water during the non-drought periods. So Thomas says the court should have overruled Florida's exceptions and just denied relief. So that brings me to the last case. So this is our final case of the week and last case of the term. And this is Janus, the American Federation of State, County, and Municipal Employees. Also referred to as AFSCME for short, just a little bit difficult to pronounce acronym there. And this case, again, a 5-4 split along conservative liberal lines, with Justice Alito writing the majority opinion, Justice Sotomayor with a solo dissent, and Justice Kagan with a dissent for all 4 of the more liberal justices. Now, this is the case about it's a First Amendment challenge to public employee unions' collection of agency fees from non-union members. Now, agency fees are fees collected by unions that are intended to cover the collective bargaining and other representational costs that unions are required to perform for all employees, including non-union members. And just for background, the key case that's involved here, this is key to this decision, is a 1977 case called Abood v. Detroit Board of Education. And in that case, the court decided it was a challenge to the collection of union dues from non-members. And what the court did in that case is it distinguished between two different types of expenses that could be charged to non-union members. And it found on one hand that union expenses that are related to involvement in political activities could not be charged to non-members. So the union couldn't charge its full dues, including money that was going to political activities. But the union could charge costs that are related to collective bargaining, contract administration, grievance processes, things like that, where the union is required by law to represent all employees, regardless of whether they're union members. It was legitimate for it to charge a fair share of those costs to all employees in the union. Now, there was a First Amendment decision where the court decided that on First Amendment grounds that the First Amendment provided against the compelled collection of union dues for those political purposes. Now, this case here, this Janus case, was a direct challenge to the Abood case. Now, Abood has been controversial among opponents of unions for a long time, and in several recent opinions, Justice Alito wrote opinions trying to cast doubt on the continued viability of the Abood decision. And this is the case finally that was the final challenge to Abood. Now, Justice Alito wrote the majority, and he did in fact overrule the Abood case, and holds that the collection of any of these fees, including the what are referred to as the agency fees, from a non-member, it violates the First Amendment's prohibitions on compelled association. Now, he framed his entire opinion around the justification for overruling Abood, this earlier case. And he starts by saying the First Amendment protects not only the right to speak, but the right not to speak and the right not to associate. And he says that compelled speech is a particularly serious constitutional concern, and says that compelled subsidization of private speech is also a First Amendment concern. He quotes Thomas Jefferson here. This is from Thomas Jefferson's Bill for Establishing Religious Freedom, very influential early Virginia law. And this is a quote. It says, quote, "To compel a man to furnish contributions of money for the propagation of opinions which he disbelieves and abhors is sinful and tyrannical." So just kind of as a little historical note in justifying the concern over compelled subsidization of private speech. Now, he starts by asking a question of what level of scrutiny should be given to this law. And now this is I'm not going to get too deeply into this right now, but in many areas of constitutional law, the court talks about tiers of scrutiny and different types of restrictions of laws, different types of restrictions on people's liberty, whether this is free speech or restrictions on other rights. The court often determines that these should be subject to different levels of scrutiny, and at the lowest level is something referred to as rational basis scrutiny, where the standard is a law will be upheld as long as it's rationally related to a legitimate government interest. But at the highest end, there are heightened forms of heightened scrutiny, The highest is what's known as strict scrutiny, where a law will only be upheld if it's narrowly tailored to serve a compelling government interest. And Alito kind of discusses the tiers of scrutiny. He doesn't decide which one necessarily applies, but he says that it's definitely a form of heightened scrutiny, because he says the rational basis, this low form of scrutiny where most laws get upheld, is foreign to First Amendment doctrine. It's not the way that the court analyzes the freedom of speech, an incredibly important constitutional protection. So then he goes on to analyze Abood. And he says, first, he talks about the original Abood case from 1977, and he looks at the interests that the government promoted in that original case. And one interest that the government promoted was promoting labor peace. But Alito says that this is undermined because the experience of the federal government, in which federal employees cannot be charged these agency fees, and also the experience in right-to-work states. So those are the 28 states that have the so-called right-to-work laws, where unions are not allowed to charge these agency fees to non-members. The experience in those states undermines the idea that there would be this great labor unrest in the absence of the ability to collect these fees in order to have a well-funded exclusive union representation. So he moves on to another interest stated in the Abood case, which was to prevent free riding. So the idea was that if these fees were not charged, then members of the union who would receive the benefits of that the union provides, including collective bargaining and representation and grievance proceedings and things like that, they would receive these benefits. But if they had no obligation to pay any of the costs in that, then there would be a strong incentive for people, even people who otherwise would approve of the union's activities, and a financial incentive for them to free ride on others, and that would undermine the whole collective bargaining regime. But Justice Alito says that this kind of prevention of free riding is just not a generally allowed rationale in the First Amendment realm. That spillover benefits are extremely common, but normally someone who is providing some benefit that spills over to others can't forcibly make them contribute to that. He goes on after that to saying that the original justifications in the Abood case don't hold up, but since then new justifications have been proposed, and he walks through those and says they also don't apply. First, he briefly addresses an argument that he says that there's an argument that's phrased as an originalist argument, saying that the First Amendment originally just didn't provide any protection to public employees. And he says that kind of an argument would undermine enormous amounts of case law protecting public employee speech and protections against political patronage, related firings and things like that. And so he says that there's no reason to treat this as different from all these other areas of law where public employees do have significant First Amendment protections. Then he looks at a line of cases that go under the name Pickering. There's a Pickering line of cases. These are a line of cases that establish the standard for public employee speech, what protections public employees have. And in those cases, the court drew a line between speech that was on a matter of public concern, so when someone was speaking to public issues, and speech that was about employment-specific matters, speech that was directed at the actual employment relationship. And the court there found that there was a significant amount of protection when an employee was speaking on a matter of public concern, but when speaking about issues of employment, there was a very limited protection that the employee had. And so what Alito says is, he says a few things. First, he says Abood was not based on Pickering, so this is just kind of an after-the-fact shoehorning in of Abood into Pickering. But he says there's several problems. He says that first, there's a few things he says about it. He says that one thing is that he says that those two categories in Pickering and the categories in Abood just don't really line up. The difference in Pickering between speech on a matter of public concern and employment-related matters, and the differences in Abood between political activities and representational activities of a union. Those categories don't really line up. He says under the Pickering public concern category, under Pickering, even when an employee is speaking on a matter of public concern, that can be overcome when there's a significant government interest. But in Abood, there's no such thing. When it's a union is dealing with political speech, purely political speech, then regardless of the significant interests, they can't charge the employees for that. So he says that doesn't line up on that side. And on the other side, he said under Abood, non-members can be forced to pay for collective bargaining, even if that public bargaining goes to a matter of public concern. And so he's saying on either side, the Pickering and Abood just don't really line up right. So he says Pickering can't really be used to justify the Abood line. He also says it's not clear that Pickering should apply to compelled speech. He says there's a difference between punishing someone for their speech and punishing someone for not speaking something that the employer wants them to speak. And he says it's not clear that Pickering should apply the same way to both these type of cases. But then he goes on to say, well, what if we apply Pickering to the Abood case and see situation and see if it fits? And he argues that it just isn't a good fit. He says that much of what happens in collective bargaining is clearly of public concern, and he runs through a lot of examples of kind of highly salient political issues that are involved in the public collective bargaining process. And one of those is budgetary concerns, where it's frequently been an issue, especially in states that have had budget crises. That public employee salaries and pensions and things like that have been a major issue of concern in electoral politics. But he also talks about a lot of other issues. He uses as education as an example, and talks about a bunch of issues that are often subject to collective bargaining agreements that are also highly controversial political issues. For example, debates about seniority-based pay versus merit pay, or the allocation of certain teachers to low-performing schools, tenure protection, teacher discipline and dismissal, the use of standardized tests to evaluate performance. Those are things that he says they're clearly things of public concern, but are still included within collective bargaining. And so he says basically that Pickering doesn't really justify the line in Abood. So having concluded that he thinks that Abood is not sound, he goes on to talk about stare decisis, and that's a fancy term for adhering to precedent. The idea the courts should be averse to overturning precedents, and should have a strong thumb on the scale in favor of sticking with prior opinions. And he says first that when dealing with constitutional cases, stare decisis is at its weakest, as opposed to, for example, a statutory case, because there the court is the only entity that has the ability to change things, that Congress can't step in when it's a constitutional rule set by the court. And then he goes through factors that the court considers when determining whether to overrule a prior precedent. And he outlines 5 factors. 1 is the quality of the original reasoning. 2 is workability. 3 is the consistency with other lines of cases. 4 is subsequent developments, and 5 is reliance interests. So how much people have kind of shaped their actions and relationships in reliance on the previous legal rule. He runs through each of these, saying, as far as quality, he says that the Abood decision failed to properly consider First Amendment interests, so it just isn't a good opinion in that respect. Workability, he says the line between chargeable expenses, those are the representational fees that unions are allowed to charge as agency fees, and non-chargeable, that's the political expenses. That line has been very difficult to draw, and has resulted in a splintered Supreme Court opinion trying to provide guidance to lower courts on that. And he says also that in practice, for a non-union member to challenge the amount of agency fees they've been assessed is a daunting and expensive undertaking, and so it's just not workable in that respect. As far as subsequent developments, he points to the enormous growth of public sector employment spending. So it's become a much more salient political issue in the time since then. And then consistency with other lines of cases. He says that the Abood case is a First Amendment anomaly in not using a heightened form of scrutiny like all other areas of First Amendment law. And he argues that this should be compared to cases about compelling employees to support a political party, which has a long tradition in American history, but where the court has stepped in and policed that stringently, unlike the people being compelled to support unions' activities. And then finally, he talks about reliance. He recognizes that there are a large number of negotiated contracts that were made under the Abood regime that has existed for the last 41 years. But he says that you can't just, the court can't just allow perpetual infringement of people's speech rights because of a contract that's going to expire in a few years anyways, because these are typically short duration contracts of only a few years. He says that also Abood doesn't provide a very clear standard of what's chargeable and not chargeable, so there can't be that much reliance on that. And he also says that the unions have basically been on notice at least since 2012. Now, that's when a case called Knox, Justice Alito wrote an opinion that was basically indicating that he believed Abood should be overruled. And he says since then, basically, the unions have been on notice that this was a strong possibility. And he says that if you're going to look at the reliance interest, you have to weigh the transitional costs to the unions in kind of learning to cope with the new legal landscape. You weigh those against what he characterizes as 41 years of windfalls under Abood, and he says that kind of reduces the unions' claim to be particularly injured by the transitional costs that result. So his result is, he says that unions cannot charge any fees to non-members without affirmative consent from those non-members. So basically, it's an opt-in policy going forward, where non-members would have to opt in to join the union or be willing to pay fees charged by the union. So that brings me to Justice Kagan's dissent. And she, emphasizes the drastic, large-scale effects of this decision, but she focuses very heavily on the stare decisis, the adhering to precedent point. And she first says, Abood, she says, it dealt with an important interest in having a well-funded exclusive bargaining agent, but it recognizes there were speech concerns, so it struck a sensible balance between political expenditures and representational expenses. And she says the interests that were supported by it were this interest in stable labor relations. The government had interest in having streamlined negotiations and being able to allow it to function properly. These stable labor relations couldn't be realized without a secure source of funding for the single union representing the employees, and that in order to have a secure source of funding, these agency fees are necessary. So she says that was kind of the justification for this the interest in Abood. And she says that there's a major collective action problem, and this is kind of the free rider issue. The union cannot prefer members to non-members. It's required to represent all non-members fairly. So it is in a situation where it can't really provide incentives to union membership to its members. So it creates this major collective action problem where people have a financial incentive to opt out of paying the union dues. And she argues that Abood actually fits well with the public employee speech cases. So that's the Pickering cases. She says that it recognizes that the government has an interest in controlling employee speech. And she says that while Pickering and Abood aren't identical, they both are striking a balance between the same competing interests, and they have a different context, because one is dealing with specifically with the collective bargaining context, and the unions, who are a separate player in the issue. Excuse me for 1 second. Excuse me. So she, excuse me. Apologize.
Sorry about that. So Justice Kagan says that Pickering and Abood, although they aren't identical, they actually fit together fairly well. She says that some of the distinctions that Justice Alito draws are based on a misreading of Pickering. She says that the division in Pickering is not about whether certain speech is in the public interest, but really it just turns on whether it's workplace-directed speech. And here, all of the speech related to collective bargaining, that's workplace-directed speech, even if it's things that are of great public interest. And she also she denies that there should be a significant difference between restricting speech and compelling speech, as Justice Alito suggested, and said actually here there's even a lessened First Amendment concern because this isn't directly compelled speech; it's only compelled subsidy of another body's speech. And she says really the key question here when talking about the government's interest in these cases is the government's interest directed at the workplace's efficient functioning? And here it clearly is. So she says that that's a legitimate interest that this supports. But she goes on to discuss the stare decisis, the precedent issue, more. And Justice Kagan, of the current justices on the court, she's the most vocal proponent of a strong stare decisis, of a strong position about adhering to precedents and being very reluctant to overturning a prior precedent. And she knows that just the whole idea behind stare decisis, behind precedent, is that sometimes it requires sticking with a wrong decision. And this has, there's important reasons for it. It allows predictable development of the law and even-handed application of the law to different parties. And that in turn encourages respect for the courts and for the practice of law. And she notes that the Abood case has been repeatedly cited favorably by the Supreme Court, including outside of the narrow area of union speech. And she notes that the political patronage cases, although Justice Alito cited those as an example that he said was inconsistent with Abood, she says, in fact, the political patronage cases distinguish between two different types of public employees, between people in policy-making positions who can be hired and required to kind of adhere to a party line and belong to a political party, and other lower ranking government employees who cannot. And so that this is kind of consistent with the types of lines that Abood is drawing also. And she basically says the only support for the majority's opinion is these two cases, Knox and Harris, from recent years with opinions written by Justice Alito that the cases weren't really about this core issue. And here's a quote from Justice Kagan. She says, quote, "Relying on them is bootstrapping and mocking stare decisis. Don't like a decision? Just throw some gratuitous criticisms into a couple of opinions and a few years later point to them as special justifications." She goes on to say Abood has proved to be perfectly workable. She says, despite this concern over the line between chargeable and non-chargeable expenses, she's not aware of any current circuit splits over those issues. And she says this reliance, that criteria, that factor, that dwarfs all the other criteria. She says there's 22 states plus the District of Columbia and Puerto Rico that allow these agency fees. That involves thousands of contracts and millions of employees. This will probably require numerous emergency renegotiations. And she really criticizes Justice Alito's characterizations of the unions as being on notice due to these previous opinions. She says this goes directly against the court's frequent admonitions to lower courts. And here's she quotes. She says, quote, "If a precedent of this court has direct application in a case, yet appears to rest on reasons rejected in some other line of decisions, they should follow the case which directly controls, leaving to this court the prerogative of overruling its own decisions." So she's saying that the court, and this is something the court says, it comes up, it's come up many times, but the court tells lower courts, just because you think our more recent opinions have somehow undermined the reasoning in an older opinion, if we haven't overruled that older opinion, you don't treat it as overruled. The Supreme Court is responsible for overturning its own opinions. So they repeatedly tell lower courts that. So she's saying, there's no basis for telling these unions, oh, you should have seen this coming, because Abood was still under this, under this kind of admonition from the court. Abood was still the governing law until the court steps in and overrules it. So she objects to that. And she concludes with some pretty strong language against the majority. She says, for example, she says, quote, "The majority has overruled Abood for no exceptional or special reason, but because it never liked the decision. It has overruled Abood because it wanted to." And she also kind of characterizes this opinion as weaponizing the First Amendment. She criticizes what she characterizes as an aggressive use of the First Amendment to kind of encroach in other areas where it doesn't belong, beyond its core area. I mentioned that Justice Sotomayor had a dissent also. She had a very short dissent where she basically just agrees, objects to the aggressive use of the First Amendment in recent years, and kind of expresses some regret in joining an opinion a few years back that she now regards as one of these over-aggressive uses of the First Amendment. So that brings me to the end of the 6 opinions for the week and the final opinions of the court's term for this year. And that kind of brings us to the end of this episode as well. As I mentioned at the beginning, I'll be doing another live stream tomorrow night. That's Thursday, June 28th at 9 p.m. Eastern Time. You can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, here's what I had planned. Excuse me. Here's what I had planned to cover tomorrow. I was going to quickly preview the 7 new cases the court granted for next term on Monday. So on Monday, the court granted 7 new cases. I'm going to preview them. Excuse me. I also want to review a few other significant orders that have come down in the past week. And I'd also wanted to take a brief look back at the entire term as a whole and kind of look ahead at how next term is shaping up, and what to expect as the court moves into its summer recess. The only question mark right now is I'm considering whether I want to dive into the Justice Kennedy retirement tomorrow or not. I'm not sure yet if I want to try and address that as well tomorrow. But in any case, that's the tentative plan for tomorrow. Whether you're watching on YouTube or listening to the audio podcast, I'd love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.